So they are all over the place, literally all over the place. So I'm trying to address them in a systematic way that would be helpful to the court. Under the Constitution, there is a couple of causes of action that are referred to. Firstly, there is Section 9 of the Constitution. And it might be that the best place to deal with it is to address it under discrimination, which is a ground of review, bias code discrimination. So at this point, I will not address it. And then the second one is fair labor practices. Now, the problem, of course, with fair labor practices is that under the principle of subsidiarity, it is not directly applicable. It is only applicable through national legislation, which could either be the LRA or the BCEA. And the legislation that has been chosen to codify Section 23 by the applicant is the BCEA. So if she's wrong on the BCEA, there is no self-standing Section 23 claim. And then the next section is Section 2195. And here, my understanding is that there is a self-standing claim to a gratuity based directly on Section 2195. But it is an utterly hopeless argument because the text of Section 2195 does not entitle the public protector to anything. Section 2195 says national legislation must establish frameworks for determining the salaries, allowances, and benefits of judges, the public protector, the auditor general, members of the commission provided for in the Constitution, including the broadcasting authority. So in its tenor and in its intention, that legislation is to impose a duty on Parliament not to determine the salaries, but to establish a framework for the determination of the salaries. So the Constitution itself does not determine anything. And it's irrelevant, therefore, to talk about salaries, allowances, and benefits. And even if, theoretically, one were to say that a gratuity is a benefit, its source cannot be Section 2195, because that section does not confer any exigible entitlements. It's simply to set out a framework. So there is nothing there. But in addition to that, it's plain that a gratuity stands apart. A gratuity stands apart. It may be provided for by the employer in its rules, in a contract. It may even be provided for by the state in a statute. But absent those rules, there is no common law right to a gratuity. So therefore, on Section 219, subsection 5, in its text there is no entitlement, and even if it fell under the category of benefits, it is irrelevant because it has not been conferred upon the public protector by any empowering instrument. What is then left of the case? On the declarator, there is nothing left. The first letter that came from the public protector on the 6th of December 2023 confined itself to the conditions of service. We have shown that the conditions of service give no rights. The pleadings then included a plethora of other entitlements from the Constitution to statutes. We've shown that under the BCEA there is no such right. Under the Constitution, there is no such right. Under the provisions of the Public Protector Act, which is Section 2, there is again no such right. The Lordship can have regard here to item 20/2054. And all this thing says is the public protector shall be entitled to such salary, allowances, and benefits as determined by the President from time to time by notice in the Gazette after taking into consideration the recommendations of the Independent Commission and approved by...
Forgive me. Why shouldn't the court construe benefit to include gratuity?
Yes, I'm making two arguments on that. The first argument is that even if your lordship took the view that a benefit may include a gratuity, you still need to determine whether it has in fact included a gratuity or not. Because it's an entitlement based on something. It cannot be an entitlement based on a supposition. So you have to say, under this particular rule, there is a right to a gratuity, and here is the rule. And here, the only domestic rule we know of are the conditions of service. So that's argument number one. So even if one accepted the argument that sometimes a benefit would include a gratuity, it is an argument that goes nowhere. I know it was pursued with a lot of fervor yesterday, but it goes nowhere. Because it still takes us back to where we started. What is the rule that entitles the public protector to a gratuity as a species of a benefit? And there's only one rule, it's the conditions of service. But we also say that in general, and this is in labor law, in general, under section, in labor law now, under section 32 and 35 of the BCEA, when one is defining a remuneration, which sometimes includes allowances and benefits, they are payments made in exchange of the services rendered. So for instance, a bonus, it may be that it's exceptional service, or for that matter, a benefit, it may be that it's medical aid or a car allowance. But they all constitute a package of remuneration that is due and payable to an employer. But when it comes to a gratuity, as the term implies, unless it's embodied in an instrument, it has no self-standing obligation that it imposes on the employer to pay it. And in fact, Your Lordship, I'm glad you've asked that question because it reminded me of something I missed when I was dealing with this. Because if you look at the actual instrument we were dealing with, which is 1839, that's the one I looked at, it has all sorts of other benefits. It has an entertainment allowance, which is not conditional upon anything, upon vacation of office or anything. It's payable. It has a medical scheme, again, that is payable, not conditional on anything. It has a motor vehicle scheme, again, that is payable. A settlement allowance, that is payable. There are two categories, and then it has a transport and subsistence allowance that sometimes is payable, but under 8.11, there is a distinction drawn between vacation of office, removal from office, and then death. But when it comes to a gratuity, it's not made automatic, not made automatically payable. Its condition is vacation of office. So these conditions of service are a very useful illustration of the distinctions that are embodied in law between your baseline salary, allowances, and which are all here, and they are called allowances, and a medical scheme, which we know is a benefit, a motor vehicle scheme, which we know is a benefit, settlement allowance, different, subsistence allowance. But a gratuity is not even classified as a benefit, not even classified as an allowance, but is a standalone category. So I was thanking Your Lordship for raising that question because I noted that I had omitted to say that even textually under the instrument, a gratuity is set out as a standalone category, not as an allowance, not as a benefit, and not as baseline salary, but as a separate category, which is compatible, entirely compatible with South African legal system, that unless it's in an instrument, you can't just say, I'm coming to court, I want my gratuity. So to answer then Your Lordship's question, we say that when you read Section 2, salary allowances and benefits, firstly, on its own text, it does not include gratuity. And secondly, in relation to the instrument that domesticates it, the gratuity is a standalone with its own conditions. And a gratuity for removal of office for misconduct and incompetence is expressly excluded. We would submit intentionally and for good reasons. So here, my Lord, we are not attempting to ask the Lordship to make any moral judgment at all. Simply an analysis of the instruments and to see whether in those instruments the right can be located. So this is then the fourth of these instruments, which is the Public Protector Act, and particularly under Section 2. So, which then, again, we ask the question rhetorically, what is left of this case? What then remains on the declarator is, well, there is some sort of unconstitutional conduct which is ill-defined. Because if you look at the framing of the declarator, it's a declaration that the conduct, that the conduct of the first or second respondents in refusing to pay the applicant the gratuity is unconstitutional. But there is no right that is relied upon in the Constitution that entitles the public protector to the payment of a gratuity against which a refusal may be measured to test its constitutional validity. There are many rights cited in the applicant's founding affidavit. None of them deal with the subject we have today. So you cannot therefore have a generalized claim to unconstitutional conduct. It has to be a specific, the right must be pleaded and it must be proved. And that is why, therefore, we cannot even debate the issue of just an equitable remedy, because we can't get past Section 172(1)(a), which is there is nothing to be declared to be unconstitutional or invalid, because no case has been proved. So if you then dismiss the case of the declarator on the analysis that I have advanced to your Lordship.
Before you, still on this aspect in relation to the category that you have put up as unconstitutional conduct. Yesterday, when Mr. Mpofu was addressing the court inquired as to what conduct was being referenced. And the court was told the following as the conduct. And there were 5 aspects were mentioned to the court. The first one was that the applicant was impeached in September 2023. Second aspect was that she is due a remuneration within 7 days after she left office. Third one was that she demanded payment of remuneration through gratuity. Fourth aspect was that the first and second respondents replied that they had no powers and asked Parliament for guidance. And the fifth aspect was that she later received a letter conveying to her that she would not be paid a gratuity. I understood entire case insofar as what constitutes unconstitutional conduct to be embodied in those 5 aspects. At least that's how the case was presented yesterday.
Yes. All right. Thank you, my lord. If we look at the pleaded case in the notice of motion, the conduct that is impugned there, it says declaring the conduct of the first and or second respondent in refusing to pay the applicant the gratuity is unconstitutional and invalid. So that's the conduct. It's the letter of the 12th of February 2024. And that is when the public protector said, you have not shown any legal instrument to entitle you to payment. So that's the case that they are asking for in the notice of motion.
So that will be the 5th aspect.
That would be
the 5
indeed,
points that I mentioned.
The fifth point, yes. So there is nothing about impeachment, although there is something about the BCEA in item 5. But we've addressed the BCEA. There's no point in repeating that. But there's also nothing about seeking a advice from Parliament or an opinion from Parliament. And there's nothing about lacking power or of any sort. So 3 of these items that were listed yesterday are just not in the notice of motion. In fact, as I understand, it was my learned friend who said that the impeachment is going on in a different, the challenge to the impeachment is going on in a different forum. So insofar as the generalized claim of unconstitutional conduct, it ultimately still reduces to the central point, which is, has she shown that she's entitled to the payment of the gratuity under the conditions of service? And if the answer to that is no, there can be no resort to an unspecified, generalized, unconstitutional conduct. So that then takes me, my lord, to the review, which is at item 6 of the notice of motion. It does require a bit of explication because of the confusing approach that was taken yesterday. There are 2 reviews that are available in our law. If one subsumes the common law under legality review. But this is not a review under the common law, it's a review under PAJA. And the second is the legality review. It's called here illegality in clause 6 of the notice of motion. So we have to do a proper analysis of the PAJA ground because the gateway to review is PAJA, the review of an administrative act. But the gateway to PAJA itself is the definition of administrative action. No 2 ways about it. So, which means that an applicant for review under section 6 and 8 of PAJA needs to prove that the decision meets the definitional elements of administrative action. I heard that my learned friend saying yesterday, we didn't object that the decision does not amount to an administrative act, but we did object. And then we said in the alternative, we will answer on the assumption that she can show that it is an administrative act and look at the grounds for review. But we objected that the non-payment, we said, is not an administrative act as defined in PAJA, and she had not proved that it was an administrative act. Now, this distinction is not a distinction we take because it is nice to take. It is a distinction of immense importance. The first reason is what was articulated yesterday by Your Lordship, emanating from the Sakhela judgment, that in law, Paja cannot be invoked unless the decision in issue is an administrative decision. But the discipline of going through the 7 factors that are listed in the Minister of Defense versus Mutau, not the current Mutau, versus Mutau, is a gateway towards the substance of the decision. Why do I say this? In Paja, in the definition of an administrative action, let's probably go through that definition, because I want to illustrate 3 elements of Paja. 20. So it is apparently at 2040. 2040. 2040. Yes, it is here. So Paja is at 2041 actually. So the first is, and this is the distinction that is drawn by Paja. It says it means any decision taken or any failure to take a decision by an organ of state when exercising a power in terms of the Constitution or a provincial constitution, or Roman II, exercising a public power or performing a public function in terms of any legislation. So if the claim that is made by an applicant is that they are challenging a decision by an organ of state, it can only be an administrative act if it is an exercise of power under the Constitution or a provincial constitution, or an exercise of public power or the performance of a public function in terms of any legislation. Those words are crucial. So if under the Constitution, it doesn't have to be public power, it just needs to be power. But under the legislation, it needs to be a public power under the legislation or a public function under the legislation. That is when you want to challenge the decision of an organ of state, which means you have to choose whether the complaint is, I am challenging a decision of an of an organ of state. Because the next question is, which power was being exercised under the Constitution, and which public power or performance of public function was being exercised under any legislation. But if you are challenging the decision of a natural or juristic person, you don't have to show that it was under a constitution or under legislation, because that is regulated by B. You only have to show that it is an exercise of a public power or the performance of a public function in terms of an empowering provision, which is a different word to legislation or constitution. So an organ of state is challengeable only where they act under the Constitution or legislation. But a natural or juristic person are challengeable where they act under an empowering provision, which need not be the Constitution or legislation. Now, Your Lordship asked a pertinent question yesterday on the Paja debate. Is the public protector complaining of a decision by an organ of state? My learned friend conceded it was a decision by an organ of state. And he in fact said, we have considered that we are an organ of state. That is true. We've said that the decision was taken by the Office of the Public Protector. But then that is not enough, because if it is an organ of state, you are in category 1, which is in terms of what clause of the Constitution and in terms of what legislation is the applicant coming to court saying the decision was taken under. Now, that exercise we did at the beginning is now very helpful to actually look at the case as it started. So we look at what she said. The request was. The request is at item 26, page 833. She said in paragraph 2.2, that's the former public protector, as you are aware, in terms of our client's conditions of service, and in particular clause 3 thereof, our client is entitled to payment of a gratuity. The final response made it clear that in terms of the conditions of service, which is at item 26, page 844, in terms of the conditions of service, she is not entitled because she was removed under section 194 of the Constitution by a resolution of the National Assembly, which was confirmed by the President. And then in paragraph 2.3, it made it clear, apart from the conditions of service, there is no other authority that our client is aware of, including the Constitution, as well as the Public Protector Act, which permits our client to consider paying your client a gratuity under circumstances where an incumbent is removed from office. So it's actually the opposite. They said, we cannot act under the Constitution. We cannot act under legislation. We can only act under the conditions of service. And under the conditions of service, a person who has been removed from office for misconduct and incapacity under section 194 is not entitled to the payment. So, Your Lordship will recall that I characterized the conditions of service as having no constitutional force, having no statutory force, only having contractual force. That then means, under the definition of an administrative act, there is no constitutional provision applicable, and there is no legislation applicable. And it fails at the first hurdle in satisfying the definition of an administrative action. And one cannot go to B either, because B says it must be a natural or juristic person, and then it says other than an organ of state. So there's an express exclusion of an organ of state. So this decision, as we know, was taken by the Office of the Public Protector, which might include all of the officials, including the public protector herself. But she was acting qua organ of state. So the first element in the definition is simply not satisfied at all, because the opposite happened here. The decision was taken under an instrument that has only contractual force. But in any event, this is an issue that should have been pleaded and proved in the founding affidavit, but it was not. It was not pleaded or proved in the founding affidavit. This is why we ended up with this oddity yesterday, when Your Lordship is asking about PAJA, and then there is a generalized reference to the pleadings, but no specific identification of the paragraphs that say this is where the elements in PAJA definition are met. And then there was a protest that said, if every time we come to court we must satisfy the 7 elements, where would we be? But the reason you have to satisfy the 7 elements is because if you cannot satisfy them, then PAJA is inapplicable, it's not available to you. And therefore you are non-suited because you couldn't establish a cause of action. That is how the legal system works. You can't just say, I want to come to court and therefore I will say anything in the founding affidavit. And then we have shown Your Lordship the first problem with the failure to apply the discipline of going through the eye of the needle, which is in PAJA. Then the second problem with it is under, it follows under B, which is the decision itself must adversely affect the rights of any person, and it must have a direct external legal effect. So let's forget about rights for a moment, and let's look at the element of direct external legal effect. We know in Dzaba, which is a judgment we have referred to, it's an employment case, and it was a dispute about promotion. A policeman came along and said, I've been denied a promotion and this is administrative action. And the court said the impact of the decision that was taken by the police is limited to you as a counterparty to the employment agreement. It is not an impact to the wider public. And PAJA is available in decisions that impact a wider public. So for instance, a tender is open to everyone. In fact, in paragraph 61, thank you, Gaba is at item 20 to 2296. And the relevant paragraphs are 64 and 65. And in paragraph 64, the last line says, well, the second last says, Section 33 does not regulate, as Section 33 of the Constitution, the relationship between the state as employer and its workers. But then this is the crucial part. When a grievance is raised by an employee relating to the conduct of the state as employer, and it has few or no direct implications or consequences for other citizens, it does not constitute administrative action. And then that is explained in paragraph 64, that the purpose behind PAJA is to regulate a specific category of decisions that have implications for the citizenry broadly. It is not to regulate a bilateral relationship, because the state acts in different statuses, different capacities. But PAJA is not intended to regulate the relationship between a bilateral relationship where one individual is affected. And the employment cases illustrate the point perfectly. And this is why they said, therefore, the decision does not constitute administrative action because it does not have direct external legal effect. It's a problem that Mr. Gaba has. This is the case here. It's a problem that Advocate Mkhwebane has. It's not the problem of everyone else. So that also still does not meet the definitional requirements, which is why it had to be pleaded and proved. And then there's a further problem, which is it must adversely affect the rights. Now, again, we need to analyze what are the rights that are affected, because the empowering instrument does not confer a right. This is not a case where a person is in receipt of a disability grant and there is a suspicion that it was fraudulently given and the state wants to take it away because they are in receipt of it and therefore they are entitled to receive it the following month. The state says it was fraudulently given and then the state wants to take it. There you can see a case where there is an adverse effect on pre-existing rights. But the problem here is that there are no pre-existing rights. And so this is now the fourth definitional element of PAJA that they are unable to satisfy. Because you look in the, you were told, well, look everywhere in the founding affidavit, you'll find portions of it. Never directed to the specific paragraphs. The problem is they don't actually satisfy the elements that are in PAJA. So, based on those four very clear mandatory requirements for the definition of an administrative action, they don't meet them and therefore they cannot plead or rely on PAJA. But if they were able to rely on PAJA, why do they need PAJA? They need PAJA because they want to contend that Section 3, subsection 1, was not complied with, which is administrative action which materially and adversely affects the rights or legitimate expectations by any person must be procedurally fair. There are obviously two problems with their reliance on this as well. The fact is, it's not every administrative decision that entitles a person to procedural fairness. It is only that administrative action that affects rights and legitimate expectations. Now, yesterday we heard very little about legitimate expectations. because there is one line in the founding affidavit that says legitimately expected, and it's not expanded whatsoever. But the case ultimately evolves on the rights that they say are enforceable. So, absent the rights, no issue of procedural fairness arises. So we come back to, can we establish a right? But even if on the theoretical assumption there is a right that has been established, the problem is, what is the ground for saying there is no procedural fairness? Because what has happened here, my Lord, is actually straightforward. You know, there is a request made on the 6th of December 2023. There is a request made, and the request contains the legal justification for it. It contains everything, because it says our client vacated the office. So they already tell the public protector that the basis for the payment is vacation of office. And they also say 1 month before the expiry of the term. And then they say the conditions of service entitle you to pay my client in those circumstances. Even yesterday, those are the only facts that Mr. Mpofu argued were necessary to establish an entitlement to payment. So the request is made, I've vacated, the conditions of service say you must pay me where I've vacated. And then there is a response that says it's common cause that you were removed under Section 194 of the Constitution, and in those circumstances you have not vacated office, and therefore you will not receive the payment. Now, it is impossible to square that up with any procedurally unfair decision. It's just impossible. Which is why we've argued in our papers that because the decision substantially complied with PAJA, because a request was made, it contained all the information that was needed, a response was given. Of course, it was investigated first because they first went to Parliament, but that was all an internal investigation. But insofar as the applicant was concerned, she made a request, it contained everything that was needed, then she received the response. So that substantially complies with procedural fairness.
You will recall the exchange between the court and Mr. Mpofu on this aspect. I inquired from Mr. Mpofu as to whether, insofar as the applicant contends for procedural regularity, whether in the context of an absence of a hearing, whether that hearing had to take any particular form.
Yes, and sorry, my Lord.
Firstly, whether the hearing had to take any particular form, and related to that, whether it is the applicant who, because she's the one who says she did not have a hearing, whether it is required of her in law to indicate to the court what the form and content of that hearing might be.
Yes.
And Mr. Mpofu's submission was that it is not required of the applicant to have done that.
Yes, well, we do not accept that, because Section 3, subsection 2, A says a fair administrative procedure depends on the circumstance of each case. So the circumstances of each case, of this particular case, is that she has made a request. It contains all of the information to justify the request, and it contains the facts, because the fact is vacation, but it also contains the legal basis, which is Clause 3 of the Conditions of Service. And then she gets a response that says your application there is no basis for us to give you the payment. So in the context of this case, that is sufficient. But if she says it's not sufficient, that's the point we make at paragraph 59 of the heads of argument. We say, in any event, the applicant does not point to any specific procedure which she says should have been followed in terms of the Conditions of Service or the Public Protector Act, bearing in mind that the procedure followed substantially complied with the requirements for procedural fairness under PAJA. The applicant was required to point to a different procedure which should have been followed in relation to a right that is legally sustainable and enforceable. She has not done so, So what she has done is to make a nebulous and a generic argument about procedural fairness, which ignores the fact of what happened here. And yesterday, what we then hear is it was because it was punitive. That's the adverse effect. But there is no punishment in saying to a person, the clause you have cited does not entitle you to a payment, and that is the position we've taken. There's no punishment there at all. She is not Robert Sobukwe, though it was argued yesterday that she was singled out like Robert Sobukwe. So we argue then on procedural fairness that the procedure followed substantially complied with what would have been required under 3, particularly because a fair procedure depends on the circumstances of each case. And if she didn't like this, she at least had a duty to say there's a different procedure in the conditions of service, or there's a different procedure in the Public Protector Act, and therefore I don't want to rely on PAJA. I have my own procedure, but we are ultimately on PAJA, and this procedure was compliant. So then we say, well, PAJA doesn't apply, but Section 3, subsection 1, read with Section 3, subsection 2, were complied with, and there can be no complaint about, no valid complaint at least about a hearing. Then I need to just address briefly I'll address the grounds of review, because it was said yesterday that it is immaterial whether the grounds are sourced in legality or in PAJA, the grounds are the grounds. But we must first address legality, because my learned friend supposes that by changing the label, you can escape the consequences of PAJA. But that is not the case. Even if you called this a legality review, the judgment of Rhino, I want to find that judgment, my lord. We've cited it in the so it's 201198.
Mr. Nkugatobi, in the citation of cases, that's in case line 20, and then the cases are numbered 1 up until the last one. It would be easier if you could just say to the court what the number
which
is.
item?
Yeah.
Oh, it's item 38, my lord.
38.
Yes.
Thank you.
So the case itself is at case lines 20/1198.
Yes, I'm there.
Thank you, my lord. And that is a legality review, and I would like to draw your lordship's attention to paragraph. Okay, it starts at 30, 31, but really paragraph 32 that really summarizes the issue, which is, in order to be entitled to launch a legality challenge, you must show an adverse effect on rights. So you can't launch a legality challenge in the abstract. It must be grounded on an adverse effect on rights. And if there is no adverse effect on rights, the legality challenge is not available. And that is what Judge Plaskett was saying. In that case, it was in the context of a premature challenge. But the principle that he makes is of general application, because he says the situation is clear. Normandy's rights have not been adversely affected by the process so far, and it can point to no prejudice on its part at this stage. So you've got to show rights, you've got to show an adverse impact on those rights. So what are the rights that are, I will ignore Mr. Mbofu's constant chatting away. What are the rights that are at issue here?
poetic when it's unprofitable, especially the undiluted and implied organist implementations. That's a different matter, but there's no remarks that not always here.
Yes, gentlemen, just reminding yourselves and everyone else that these are court proceedings.
No, it is the case, my lord. So when someone is always commenting and speaking loud, and then when they are called out on it, they protest. So what are the rights at issue here? There are no rights at issue because none have been established by reference to the conditions of service. And so it does not help to say, I don't have a PAJA claim, but I have a legality claim, because that just changes the label. But it does not excuse you from establishing the requirement to show that rights are impacted. So whether, therefore, they go under PAJA or they go under legality, the fact is they must still establish rights. And absent those rights, the claim cannot proceed. Then, if PAJA or legality are not available, and perhaps I may be wrong on that, what do I say then about the grounds of review? I've addressed the audi alteram partem rule. It was relabeled yesterday as procedural unfairness once it became a problem to go through the PAJA requirements. Relabeled as procedural irrationality. Yes, not unfairness. As procedural irrationality. But your Lordship remembers the judgment in Law Society versus the President, which made this point very clear that when it comes to procedural irrationality, that has nothing to do with whether or not an affected party was given audi before the decision was taken, because that is procedural fairness. When it comes to procedural irrationality, the question is whether or not the decision maker took into account all of the relevant factors in order to rationally arrive at a decision. So it is an inquiry into rationality. Sometimes, as it happened in the case of Scalabrini versus Minister of Home Affairs, sometimes the taking into account of relevant circumstances would impose a duty to hear a party likely to be affected by the decision. In Scalabrini, it was whether or not the government could close a refugee center without hearing the NGOs that made use of the refugee center. In Albert, the case was whether or not the government could introduce a scheme of amnesty without hearing from the victims. But the ultimate point is whether at the time you took the decision, you took into account all of the relevant circumstances and factors in order to arrive at a decision rationally. We then come back to domesticate the problem. In this case, they told us themselves on the 6th of December 2023, they told us themselves that they want to be paid because they have vacated office, and they want to be paid because they're entitled to the payment by virtue of the conditions of service, particularly Clause 3. And when the decision is arrived at, which says that there is no cognizable claim under Clause 3, that is having regard to the representations that have been made by the affected person who is interested in the outcome. It's not ignoring them. It's taking them into account because they wrote the letter. And so it was before the public protector. So there can be no complaint, at least no valid complaint. I know there was a lot of complaints yesterday, but there can be no legally valid complaint that this was on a procedural irrationality basis. This was a decision arrived at without taking into account the views of the person that would have been affected by the outcome because they triggered the process themselves. So that takes care of both Audi and the so-called procedural irrationality. There's just no case there whatsoever. And then we have the complaint of bias. Probably the best is simply to direct your lordship to the pleadings, particularly in the answering affidavit. So your lordship will find this we have dealt with it at page 29/21 of the answering affidavit. The answering affidavit itself starts at 29:2. And the answers are at 29:21. So in paragraph 19, it's the point I've already made. The decision not to pay the applicant a gratuity was both procedural and substantively correct since it did not involve a right that is legally sustainable and enforceable. And then in paragraph 19.2, that is a discrimination point. As I understood the argument, it was bias, stroke discrimination, stroke ulterior motive, stroke malice. But here is the answer at 19.2. The decision is not discriminatory. She's not being singled out. No grounds for discrimination or unfairness have been specified or established by the applicant. As I will explain below, the previous public protectors received the gratuity payout because they vacated the office after serving for the full 7-year term. The applicant, on the other hand, was removed from office as a result of her misconduct and incompetence. This differentiation is fair and rational. Then, if you turn over the page, 19.4, again, as I will demonstrate below, the applicant's allegations of bias, malice, and ulterior motives are completely unfounded and ought to be rejected. Now, you will obviously see the full explanation at paragraph 63.4. That you will see at page 29/33. I reiterate that the decision was not taken as a punishment or sanction, as illustrated by the process undertaken. Once it became clear that there was no authority on the basis on which a gratuity could be paid to a public protector who has been removed from office, I was not empowered to make such a payment. There is thus no basis to refer to representations on mitigation or reasons to avoid a sanction. And then paragraph 65 and 66. So the substance of it is actually straightforward. What they told her on the 12th of February were three things. One, you have been removed from office as a consequence of Section 194. Number two, the National Assembly has passed a resolution for your removal. Number three, the President has sanctioned your removal for misconduct and incompetence. We know those two documents. And then they say, but we compare your situation, even if you compare your situation to the previous public protectors, none of them were removed from office to start with, let alone being removed on grounds of misconduct and incapacity. Misconduct and incompetence. Now, this is why it was interesting to hear yesterday that there was somehow a suggestion that that these grounds were not in the letter. The Lordship's immediate retort was that, but the letter does contain the grounds. Then the argument went on, because they are encapsulated expressly. It's one thing to say it's implied. They're expressly encapsulated in the letter of the 12th of February. And this is what explains then why, when you look at our heads of argument, and again we have to address this because of the accusations of bias, accusations of unfair treatment, accusation of ulterior motive, accusations of malice. This is why then when you look at our heads of argument from paragraph 36, we have to spell out what that Section 194 committee, which is referenced in the letter to the public protector, found. For instance, to incompetence, it said, in relation to the charge of incompetence, as assessment of the evidence must reflect a demonstrated and sustained lack of knowledge to carry out and ability or skill to perform the duties of the public protector effectively and efficiently. At 36.12, the report finds that the applicant litigated recklessly and committed misconduct in utilizing the public protector resources to obtain legal advice and commencing litigation for personal gain. The report found that the applicant spent over 50 million rands on legal costs for litigation relating to 6 matters. The report noted at paragraph 244 that these costs are exacerbated where there are obviously no prospects of success and perpetual applications for leave to appeal. It continued that, save for one matter, Advocate Mkhwebane instructed that litigation on these matters ensue with several appeals and failed on the merits in all of them. And we look at the summary we gave at clause 36.2. The evidence shows lack of impartiality, particularly in relation to the SARS Rogue Unit report. And that undermined her credibility and integrity. Number 2, she was found to be in unlawful possession and utilization of classified information because she was in possession of a classified report by the Inspector General of Intelligence. She unlawfully received it, she perused it, and that constituted misconduct. And then she was in gross overreach of her powers. The evidence demonstrated that the applicant grossly overreached and exceeded her constitutional bounds. In this regard, her directive to Parliament to initiate a process to amend the Constitution represented a flagrant violation of Parliament's exclusive authority, showcasing her incompetence and disregard of legal boundaries. And the last one, alteration of reports and mismanagement of resources. The committee found that the applicant's alteration of the final report of the Freddy Dairy matter, giving implicated parties discretion to determine wrongdoers, removing referrals to investigative bodies, and producing untruthful explanations to the court, constituted serious misconduct. Additionally, her mismanagement of resources, leading to astronomical legal bills and expenditures, further demonstrated incompetence and negligence in her duties. So we can ask the question then, which other public protector in the history of the Office of the Public Protector has ever had these findings made against them? The answer is that it is Advocate Mkhwebane. And so when the Office of the Public Protector says to her, in these circumstances, we are unable to locate a statutory authority to pay you a gratuity, they are not being biased against her. They are not being malicious against her. They are not being unfairly discriminatory against her. They are telling the truth. Any other finding is just a distortion of the truth. They're telling the truth. So your Lordship can then, on bias, unfair discrimination, malice. Yes, my junior. So let me just complete the sentence. On bias, unfair discrimination, malice, those ultimately revolve around a single fact, that everyone else was paid and I was not paid. Then we deal with the matter in any event of the other public protectors, the comparator, at page 29/10, where in paragraph 14.5 we say the three people, what she says, the three people appointed to the position of public protector prior to the applicant had held the office until the expiry of their 7-year term. Advocate Selby Bako was appointed on the inception of the office in 1995 and remained in the position until 2002. He was succeeded in 2002 by Advocate Lawrence Mushwana, who served as the public protector for the 7-year term until 2009. In 2009, Advocate Thuli Madonsela was appointed as the public protector. She too served in the position for the full 7-year period. Oh yes, apparently what I should have read is 14.4, which is, this was the first time that the National Assembly had invoked the procedures prescribed in Section 194(1) of the Constitution for the removal of a public protector, and the first time that the President had removed an individual from the office of the public protector in terms of Section 194, subsection 3, subsection B. So again, Advocate Mkhwebane is not Robert Sobukwe. She is not getting the gratuity because the instrument does not permit the payment of a gratuity to a person removed from office for misconduct and incompetence. Then the next ground of review is the taking into account of irrelevant considerations. But when you ask yourself, well, what are the irrelevant considerations? And the reason why, again, one needs to drill down to the evidence is because the considerations that the public protector advanced should be taken into account are at page 18/82. Those are the considerations she claimed should be taken into account. She said, our client vacated the office on or about 12 September 2023, 1 month before the expiry of a term of office. Now we know the sequence here. 11th of September, the Parliament passes, the National Assembly is passed. 12th of September, the President issues a letter removing her from office. Paragraph 2.2, as you are aware, and in terms of our client's conditions of service, and in particular clause 3 thereof, our client is entitled to payment of a gratuity. Those are precisely the considerations they took into account when you have regard to page 18.87. They said you've been removed as a result of a resolution of the National Assembly, which the President acted under in terms of Section 194. And then they said, we've also looked at these conditions of service, and we have established that under the conditions of service, vacation is not removal, and therefore you are not entitled to payment. So there are no irrelevant considerations that were taken into account. In fact, the considerations that were taken into account were foreshadowed by the public protector in her correspondence and then responded to by the previous public protector and then responded by the public protector. They are highly relevant insofar as they inform the correct decision-making matrix. And then, my Lord, that takes care of the review. To sum it up, they have not shown that there is an administrative action that would trigger the application of PAJA. They have not shown that any rights that they have in law are adversely impacted, which would trigger the application of the legality principle. They are just wrong when they claim that there has been a change in the reasons. That's just wrong. It's not the case. Your Lordship just needs to look at the letter. What has happened, of course, is that an answering affidavit fleshes out the reasons, but it's the same reasons. And then they cannot show that there is any irrational discrimination. And the fact that a public protector who has been found guilty of misconduct and incompetence and removed from office as a result of that does not get a gratuity is completely compatible with the scheme of the Constitution. It's totally compatible. It is an objective fact, not targeting an individual, because anyone else who falls into that category will know from now on that South African law says I have to respect my oath of office when I assume that position. If I act in violation thereof, I will not get my gratuity. End of the story. But it is also a factor that serves a legitimate constitutional purpose. It is an entirely legitimate constitutional purpose to say that as a matter of South African law, someone who has no respect for the oath of office should not get the gratuity. And that legitimate purpose, and Mr. Mutau has articulated this better than us in the heads of argument, is constitutional accountability. And hopefully he will expand on the concept. It's constitutional accountability. Because the values that are in Section 1, which include accountability, apply across. They apply even with stricter validity when it comes to a person whose primary job is to uphold the Constitution. And this is why in our heads of argument we've relied to the South African Reserve Bank case to say the holder of that office is the primary instrument through which South Africans expect the values of the Constitution would be lived. And when there is a negation and a disregard of the values of the Constitution by the holder of the office, that is meant to be a standard setter for all of us, it is a legitimate thing for the law to say, in those circumstances, there will be no gratuity. It is an entirely legitimate thing. Otherwise, what you have is a free-for-all. What you have is a reward for constitutional delinquency. And this, I'm afraid, my Lord, is the big elephant in the room. But this case, really what it is about, is asking the judge to be party to a reward of constitutional delinquency. So we say that the distinction, it's true that there is a distinction, but it is a rational distinction. It is also an objective distinction. It also serves a legitimate constitutional purpose. And that is why we submit, therefore, that your Lordship will not find that there are other reasons outside of the declarator, the review, and some other freestanding constitutional reasons. We then say to your Lordship that there is a costs issue that needs to be addressed. We have seen in the arguments made that there is a personal cost that is sought against Advocate Galega. But it has no basis in law and no basis in fact. We have addressed this at paragraph 69, 70, and 71. In fact, the correct approach, my Lord, which is from the judgment of Zuma versus Democratic Alliance and another, an SCA judgment, particularly at paragraphs 47 to 52. What you have here, you've got a part...
Paragraph, what, 52?
Yeah, 47 to 52. It's a judgment by, I think it's Judge Ponan, if I'm not mistaken, but we've cited this at footnote 108 of our heads of argument.
Right.
The correct approach in cases like this, my Lord, is that if you have an applicant that comes to court with a slew of reckless accusations which cannot be established on fact, and insults, quite a lot of insults that cannot be established on fact, of malice, of bad faith, of vindictiveness, of bias, of not taking a decision that is genuine. And that tenor, which is a series of outlandish allegations, runs through the founding affidavit and the supplementary affidavit. I'm afraid also in the heads of argument. And yesterday, you would recall accusations of manufacturing the pleadings. Now, that runs through the entire founding affidavit. The Supreme Court of Appeal has said this must end. Now, unfortunately, there is a sense of helplessness among the judges about how exactly do they address this kind of litigation, where instead of setting out a case and a legal case for the basis of the case, what then happens is that the case is then expanded to cover extraneous matter, which is nothing but insult. Sense of helplessness among our judges about how to address this. At the very least, Judge Ponan said, one of the powers we have is costs. At least that is still within judicial control, is costs. And costs must also be awarded in a case where outlandish allegations, which have no bearing on the matter, are made to color the texture of the affidavit and to color the atmosphere of the hearing. And so that is why we ask that it's actually the opposite, is that in the light of the manner in which this case has been litigated, it is necessary, regrettably, to ask your Lordship to follow the line of Justice Ponan, which is, but this thing must end. At some point it must really come to an end. And that's why we ask that when you consider costs, you've got to consider a punitive cost against the applicant, which would be on an attorney and client scale. My recollection is that that was the cost order imposed by Judge Ponan as a mark of displeasure to this kind of litigation. Thank you, my Lord.
Thank you very much. Mr. Mutau?
My Lord, I wonder if Mr. Mutau doesn't want to come here.
In fact, I do, my Lord. It would require that we